New Mexico Real Estate Basics, page 24. Agency. One broker is appointed to exclusively represent the seller. Another broker in the same office is appointed to exclusively represent the buyer. What is dual agency, and is it legal in New Mexico? New Mexico law authorizes the use of disclosed dual agency, provided the brokerage has a company policy permitting its use. Dual agency is created when both parties to a transaction give written authority to one broker to represent both parties as an agent in the transaction. Dual agency also occurs when the qualifying broker of the firm is an agent of either party, and an affiliated broker is agent for the other. An individual using dual agency is really not representing either party to the transaction, but instead becomes a facilitator, not taking sides in the negotiation. In offices that do not choose designated agency, dual agency may also occur when two affiliated brokers represent parties in the same transaction. The practice of dual agency requires informed written authority in the form of a separate dual agency agreement. What is designated agency? In New Mexico, the qualifying broker may designate different brokers affiliated with the brokerage to exclusively represent clients in an in-house transaction. These designated agents work as exclusive agents for either the seller or buyer to the exclusion of all the other brokers within the brokerage. Therefore, two brokers from the same real estate brokerage end up representing opposite sides in a single real estate transaction without creating a dual agency. Under New Mexico rules, a designated agent is not considered a dual agent. Remember, dual agency cannot exist unless the agent personally represents both the buyer and the seller, or the broker's qualifying broker also represents one of the parties as an agent. Using designated agents is an effort to avoid the potential conflict of interest inherent in dual agency and to clarify that not every broker within a brokerage represents every client of the brokerage. Who is a customer, and what does the agent owe the customer? A customer is a consumer of real estate related services who has no written agreement with the broker. While providing brokerage services to customers, brokers must do so honestly and in good faith. They must diligently exercise reasonable skill and care, and brokers must disclose all adverse material facts that they know. In addition, there is a duty to account for any customer's property that comes into a broker's possession. Who is the broker's client, and what does the broker owe this client? A client is a party to a transaction who has a written agreement with a broker for brokerage services. Another name for a client is the principal. The principal is an individual who hires and delegates authority to a broker to represent the interests of the client. The principal can be the seller, landlord, buyer, or tenant. The broker may represent the principal as an agent, or work with an individual as a transaction broker.